Crown Copyright 2023. Neutral Citation Number, 2024, UK FTT 00815, GRC. Case Reference, FTE A20240064. First Tier Tribunal General Regulatory Chamber Information Rights. Heard by CVP. Heard on, the 21st of August 2024. Decision given on, the 17th of September 2024 before. District Judge Rebecca Worth authorized to sit as a tribunal judge in the GRC, Tribunal Member Suzanne Cosgrave, Tribunal Member Rosalind Tatam. Between Sajad Hussain, Appellant, and the Information Commissioner, Respondent. Representation: the appellant represented himself, the respondent did not attend and was not represented. Decision: the hearing is not adjourned to enable further information to be provided by Mr. Hussain and the appeal is dismissed. Definitions: DN, the decision notice, which is the subject of this appeal, namely ICO FTT 55075F1 dated the 19th of January 2024, year amended here as the DN clearly has a typographical error. FOIA, Freedom of Information Act 2000, ICO. The Information Commissioner's Office. PA. The public authority, as defined by Schedule 1 of FOIA, namely City of Bradford Metropolitan District Council. The requester, the person who applied for information, referred to in FOIA, Section 1 as the applicant. The rules. The tribunal procedure, First Tier Tribunal, General Regulatory Chamber, Rules 2009, C 2010 43rds, as amended. Mode of hearing. The tribunal was satisfied that it was fair and just to conduct the hearing using Cloud Video Platform, CVP, all parties were able to join remotely. The ICO decided not to attend or be represented. Mr. Hussain joined by telephone call. Reasons. The hearing, not adjourned. 1. Prior to the hearing, the tribunal received the open bundle, a closed bundle, the tribunal's directions dated the 16th of July 2024 and the 17th of July 2024 and Mr. Hussain's email, with hyperlinks, sent to the tribunal on the 13th of June 2024 at 11:33 a.m. 2. At the start of the hearing, the judge told Mr. Hussain the tribunal panel had not accessed the links. It was explained that this was because there needs to be certainty at any appellate court, whether it be the upper tribunal or higher, what documents were before the tribunal panel when the decision was made. In addition, the issue for this tribunal is narrow as this tribunal can only decide the issues about FOIA. Here, the issue is whether the information he requested was properly refused to him under FOIA. 3. Mr. Hussain was invited to talk to the panel about what, within the "what do they know" information that he referred to in his email of the 13th of June, demonstrated that the tribunal should allow his appeal, and he was invited to explain what, within the YouTube links, was relevant to the issue in this appeal, the application of FOIA to his request. He described sections of information contained in the main "what do they know" link, a number of which were in the bundle before the tribunal. 4. The panel were of the view that they did not need to access the links to determine the appeal. Towards the end of the hearing, the judge asked Mr. Hussain whether 2. He wanted time to provide further documents, e.g. a PDF of the "what do they know" pages that he referred to. Mr. Hussain had himself already asked for an adjournment for reasons unrelated to the documents. Although he was clearly of the view that it was the fault of the ICO that those pages were not contained within the bundle, he did not indicate that he wanted an adjournment in order to provide more material. The judge said that the panel, as part of the deliberations, would decide whether to allow an adjournment for Mr. Hussain to provide further documents or for the other reasons he had advanced. 5. The panel decided that, as the issue before the tribunal is about FOIA and its application to Mr. Hussain's request, it was not necessary to adjourn the hearing for further information to be provided. And the other arguments, including police investigation, were not relevant to the FOIA issue being considered, and so proceeded to determine the appeal. The Law 6. As far as is relevant, FOIA provides general right of access to information held by public authorities. 1. Any person making a request for information to a public authority is entitled a. To be informed in writing by the public authority whether it holds information of the description specified in the request, and b. If that is the case, to have that information communicated to him. 2. Subsection 1 has effect subject to the following provisions of this section and to the provisions of sections 2, 9, 12 and 14. 3. 4. The information in respect of which the applicant is to be informed under subsection 1 or b, which is to be communicated under subsection 1b. Is the information in question held at the time when the request is received, except that account may be taken of any amendment of deletion made between that time and the time when the information is to be communicated under subsection 1b. Being an amendment or deletion that would have been made regardless of the receipt of the request. 3. 5. A public authority is to be taken to have complied with subsection 1 in relation to any information if it has communicated the information to the applicant in accordance with subsection 1b. 6. In this Act, the duty of a public authority to comply with subsections 1a is referred to as the duty to confirm or deny. 7. Section 40 of FOIA, as relevant to this appeal, provides 1. Any information to which a request for information relates is exempt information if constitutes personal data of which the applicant is the data subject. 5a. The duty to confirm or deny does not arise in relation to information which is, or if it were held by the public authority, would be exempt information by virtue of subsection 1. 8. There is a process of challenge. The first challenge is for the requester to apply to the ICO for a decision notice, FOIA, section 50. If either side, the requester or the PA, wishes to challenge the ICO's decision notice, they are entitled to appeal to this tribunal, FOIA, section 57. This tribunal's powers are found in FOIA, section 58, which provides determination of appeals 58.1. If on an appeal under section 57 the tribunal considers that the notice against which the appeal is brought is not in accordance with the law, or b. to the extent that the notice involved an exercise of discretion by the Commissioner, that he ought to have exercised his discretion differently, the tribunal shall allow the appeal or substitute such other notice as could have been served by the Commissioner, and in any other case the tribunal shall dismiss the appeal. 2. On such an appeal, the tribunal may review any finding of fact on which the notice in question was based. Background. 9. Mr. Hussain asked the PA for information relating to a fraud investigation and conviction. 4. 9.1. The request was made via the What.Know website on 6 May 2023 and its terms can be found at paragraph 5 of the DN. There were 5 parts to the request. The part which is relevant to this appeal can be read as follows. On a date in 2018 you responded to a question with the answer, a resident within the local authority has been fined X1 and jailed X1. The individual your response relates to is obviously myself. My FOIA question is, how much money has been returned to the residential victims of this crime? 9.2. The PA responded on 28 June 2023, providing information in relation to parts 1 and 2 of the request. The PA stated it did not hold information in relation to parts 3 and 4 of the request. It refused to provide information requested at part 5, stating it was exempt under section 40 of FOIA, the personal information exemption. 9.3. On 25 July 2023, Mr. Hussain requested an internal review. 9.4. The PA maintained its original position when it reviewed the request on 21 August 2023. The PA, on 22 August 2023, amended its response to Part 1 of the request by correcting some information which had been provided. 9.5. The DN, dated 19 January 2024, found that the PA is entitled to rely on Section 40(5)(a) of FOIA to refuse to confirm or deny whether it holds information which falls within the scope of the request. See paragraph 2 of the DN. The ICO found that the PA had breached the time limits for responding. The ICO did not require the PA to take any steps. 10. Mr. Hussain, by notice of appeal dated 19 February 2024, and received the same day, appealed the DN to this tribunal. Grounds of Appeal 11. The grounds of appeal set out, as relevant. I look to appeal the ICO's decision of 19 January 2024 on case reference #ICO FTT255074T5F1, given the following statement made by the Commission on this decision. The Commissioner considers that by confirming or denying that it held information within the scope of the request, the Council would confirm to the world at large whether or not the complainant had been investigated for fraud. This would be the personal data of the complainant. 5. Therefore it is plainly clear that I as the data subject want this information to be released, to the world at large, and the Commissioner is wrong to try to stonewall or undermine my attempts to draw public attention to this unprecedented action taken by the local authority. City of Bradford Metropolitan District Council, CBMDC. 12. It is evident, therefore, that the only part of the request that Mr. Hussain has made the subject of this appeal is the response to question 5 and the DN conclusion that the response was wrong as the PA should have neither confirmed nor denied whether the information was held. Response. 13. The ICO's response is dated 22 March 2024 and responds as follows to the key issue. 13.1. Mr. Hussain identifies this information as his personal data. Such information is not available to him via FOIA. Appellant's reply 14. It appears that Mr. Hussain did not file a reply to the ICO's response. Mode of hearing. 15. Mr. Hussain chose not to consent to a paper consideration, as is his right. The tribunal, therefore, held a hearing and parties were notified of the hearing time and date. 16. The tribunal notes that the ICO, since their response to the appeal, stated they did not intend to attend or be represented at the hearing. The tribunal also notes that the ICO was represented at the case management hearing which took place on the 16th of July 2024 and notes that Mr. Hussain did not attend that hearing, despite being notified of the hearing. 17. Mr. Hussain attended the tribunal hearing on the 21st of August 2024. At the hearing, he made submissions, setting out to the panel why he believed that he would not get a fair hearing, why he believes that the information he requested is not personal data, and why this information is so very important. He also explained why he believes the information, amount repaid to residential victims of the crime, should be given to him by the PA under FOIA. This decision focuses on the FOIA issues and, therefore, the whole of Mr. Hussain's submissions are not outlined here. Evidence and submissions 18. The tribunal considered 18.1. An open bundle comprising of 90 PDF pages. 6. 18.2. A closed bundle which contained unedited copies of emails between the ICO and the PA, edited copies having been included in the open bundle. 18.3. An email from Mr. Hussain, sent on the 13th of June 2024 at 11:33 am to the tribunal and ICO which contains links which the tribunal panel has not accessed or viewed. 18.4. Case management directions dated the 16th of July 2024 and the 17th of July 2024 discussion, was this a fair hearing? 19. The hearing took place using cloud video platform. Mr. Hussain joined by telephone. It is not known, and not relevant, why he did not join using a device which enabled him to be seen. 20. Prior to the hearing of the substantive appeal, there was a case management hearing. At that hearing, as can be seen from the case management directions dated the 16th of July 2024, the ICO was represented, and Mr. Hussain did not attend. Paragraph 7 of those directions sets out that the bundle, in the ICO's view, already contained Mr. Hussain's evidence, except for the videos which could not be included in the bundle. 21. Mr. Hussain would, perhaps, not agree with that assessment as he indicated that, in addition to the documents that are in the bundle, accessing the links he provided would permit the panel to see a document or documents that are missing. He informed the tribunal that on or around the 16th of March 2024, he left a note on the What Do They Know website which is a summary of the confiscation order made by a Crown Court judge. That note, he told the tribunal, provided the financial details contained within the confiscation order which is the information he was seeking from the PA in Q5. Such note does not appear within the bundle and this is, perhaps, a reminder of why it is important that each party to an appeal ensures that the bundle contains all the documents that they believe are relevant to the appeal. 22. However, whether the bundle did, or did not, contain all the information that Mr. Hussain thought relevant, it is clear that, overall, he had the opportunity to present all the relevant information. 23. Mr. Hussain did not make representations about the contents of the YouTube videos. He would have been able to make submissions about those and was, at the outset of the hearing, informed that he was permitted to do so. Discussion, is the information Mr. Hussain's personal data? The pages edited in the open bundle are D71 to D73, D75 and D77 to D79. It is unclear why the tribunal needed to see the phone number which is edited from pages D73 and D79 but nothing turns on that issue. It is for the tribunal to decide the issues on which it requires evidence, see Rule 15 of the rules. 7. 24. Mr. Hussain's point on this at the hearing was a very fair one. He asks for a figure, how much money has been returned to the residential victims of this crime. He does not see how that is personal data at all, because he wants a figure. 25. The issue is, however, that the only way to answer that question is to know that a. There were victims and b. What money those persons have received. The only way to answer that is to provide some biographical information about the persons involved, namely that they were a victim and that they have, or have not, received money. 26. The further issue, and this is the one which the ICO picked up on, the PA not having done so, is that when you look at the whole of the request, it is clear that Mr. Hussain is asking for information about him personally. This is evidenced by the sentences which precede the questions, namely, response to a previous request by a different person, a resident within the local authority has been fined X1 and jailed X1. The individual your response relates to is obviously myself. In this regard I have the following questions. 27. Mr. Hussain's grounds of appeal included that he wants this information to be publicly known. He explained to the panel that this is because he considers he was falsely convicted by a private prosecution and his family is suffering as a result of actions taken by the PA. However, it remains that the information he asked for is about him and, therefore, not available to him under FOIA as personal information is specifically excluded under Section 41 of FOIA. 28. The DN, however, went one further step and said that the correct response, under FOIA, was to have neither confirmed nor denied whether the information was held. The DN, at paragraph 14, sets out the reasoning for neither confirm nor deny. 14. The Commissioner considers that by confirming or denying that it held information within the scope of the request, the Council would confirm to the world at large whether or not the complainant had been investigated for fraud. This would be the personal data of the complainant. 29. That conclusion is correct. Whilst Mr. Hussain, it appears, wants the world to know about his conviction, because he says it is a false conviction, an FOIA request is not the mechanism by which he can cause further information to be placed into the public domain. The ICO was correct to tell the PA that the correct response would be, neither confirm nor deny. 30. As we have concluded that this information is Mr. Hussain's personal data, the information becomes absolutely exempt from disclosure to him under FOIA. Any role he took as a whistleblower, any public interest argument and even the fact 8. That much information is in the public domain does not assist because, in simple terms, Mr. Hussain's personal data is not available to him via FOIA. Conclusion. 31. For the above reasons, the tribunal panel concludes that the DN was correct to conclude that the correct response by the PA would have been to neither confirm nor deny whether they held the information. Signed, District Judge Worth, authorized to sit at a first-tier tribunal judge for the General Regulatory Chamber. Date, the 30th of August 2024. 9.